Chapter 8. Under U.S. law, a criminal defendant is entitled not only to be informed of the charges against him, but through a process called discovery, the defense may demand of the prosecution any exculpatory evidence that has been collected in the course of its investigation. As Ted's trial date neared and John O'Connell read over the evidence, he felt with increasing certainty that Thompson and the rest of the police were trammeling his client's rights. Specifically, O'Connell was persuaded that the key evidence, Carol Duranche's identification of Ted as her abductor, had been coerced. It was O'Connell's proper role to be indignant on Bundy's behalf, and he was among the best in Utah at summoning righteous outrage at the propitious moment. Tall and gaunt, O'Connell can bring to mind Jeremiah in a three-piece suit. So exercised had he become over the Bundy case that he once raged to one of the cops that the police should simply shoot Ted if they were so positive he was a killer. That, O'Connell argued loftily, was preferable to stretching the law to gain a conviction. The attorney was also deeply concerned about the public mood in Utah. Picking a jury for a man suspected of murder for hundreds of miles in every direction was going to be trouble. So, several weeks before the scheduled February 23, 1976 start of Ted's kidnap trial, O'Connell suggested a bold ploy to Bundy. Why not waive his right to a jury and go with the assigned trial judge, Stuart M. Hansen, Jr.? O'Connell persuaded Ted of the wisdom in waiving a jury with a formidable set of arguments. There's nothing to be done, he pointed out, about the presumed taint on jurors' attitudes after months and months of publicity, innuendo, accusations, and speculation. In most states, a locally infamous defendant can have his trial moved to some distant community where the pool of prospective jurors is less likely to have been tainted by press coverage. But in Utah, there was no town big enough and distant enough from Salt Lake City to which the proceedings could be moved. Also, the state's rules under which jurors can be questioned as to their possible biases allow for no attorney participation. Voir dire, as it is called, in Utah was conducted exclusively by the judge. As Bruce Lubeck, O'Connell's associate, said, around here, if you have bad pre-trial publicity, you're in trouble. Another consideration was the nature of the state's case. They had an eyewitness identification, said O'Connell. Now, eyewitness testimony is lousy testimony. The guy on the street thinks circumstantial evidence is weak, but it is a whole lot more trustworthy than an eyewitness. Yet it is the most likely thing for a jury to convict on. So our theory was, why not go with one juror that we know is intelligent rather than 8 or 12, gosh, only knows what. The clincher was Hansen's record on the bench. In a state where the line between the rule of law and the tenets of Mormonism can sometimes be blurred, Stu Hansen had built a reputation for unflinching adherence to legal principle. Time after time, Hansen had directed unpopular acquittals on technical grounds in drug cases. Just before Ted's trial, he presided over another controversial matter, an obscenity prosecution of the porn movie Deep Throat. Around here, that was a pretty heavy deal, remembered Lubeck. He dismissed the case because he felt the city had neglected to prove something, didn't even give it up to the jury. We felt that was an indication Hansen could stand up to public pressure. Ted's trial began on Monday morning, February 23, 1976, in room 310 of the old Salt Lake City courthouse. A thin winter light bled through the tall windows behind Judge Hansen's impressive dark wood bench. And an added propitious note for the defense, Hansen was in large measure ignorant of the controversy Ted had provoked. He had been away at a judicial gathering in Nevada for several weeks during the peak of the publicity, and amazingly knew nothing of the several other murders to which Bundy had been linked. I was just not really aware of what this case was all about, Hansen told us. You may think I was wandering around in a fog, and maybe I was. He was well aware that added security had been arranged for the trial, which explained the beefy, saturnine deputy sheriff sitting in the otherwise vacant jury box. But as Stu Hansen surveyed his high-ceilinged, red-carpeted courtroom, he was astonished to find every available seat taken. Before him were his old law school classmates, John O'Connell and David Yoakum, posed for their ritualized combat. Next to O'Connell sat Bruce Lubeck. We were very confident we were going to win, Lubeck remembered. It wasn't so much that we had anything, it was just that they didn't. The defendant himself came to court in a blue suit that Sheila Vortman had helped him pick out. Ted was tanned from a short ski trip he'd taken just before the trial and appeared relaxed and self-assured. Johnny and Louise came to the trial and sat together in numb astonishment toward the rear of the courtroom. Their presence made Ted uncomfortable. While in Salt Lake City, they would stay with Michael Priest, the president of Ted's Mormon ward. Louise especially found her son's abstemious Mormon friends to be warm and hospitable in this, her family's hour of need. But she still hadn't gotten over Ted's sudden switch in religions, and never would. Across the aisle from the Bundys sat Debbie Kent's mother, Belva, with her thoughts of her missing daughter. Nearby, Melissa Smith's father, Midvale Police Chief Lewis Smith, sat rigidly, hatred for Bundy evident in his face. At the request of both defense and prosecution, Jerry Thompson had made sure that Smith didn't carry a weapon into court. Smith knew by this time that Bundy had gone on a weekend hunting trip with Liz Kendall's father the day after Melissa disappeared. If, as her autopsy suggested, she had not died immediately, then where and in what state had Ted kept her? All discovered by now had been 2 strands of human hair, one in the trunk of Ted's Volkswagen, the other at the base of his gear shift. One of the strands, according to an FBI lab report, was quote-unquote microscopically indistinguishable from Karen Campbell's hair. The other was the pubic hair, equally alike to a sample from Chief Smith's daughter. Had there been any more evidence, anything, Smith knew that Ted would be on trial for his life that Monday morning. Toward the back of the courtroom, Judge Hanson's 15-year-old daughter caught O'Connell's attention. At the sight of her, he reflected that he and Hanson were the same age, and already his longtime friend had a teenage daughter. John O'Connell suddenly felt old. He nudged his client and pointed at the girl. Throughout the trial, Bundy felt the girl's ceaseless gaze. She sat there staring at me, he recalls. I swear, it gave me the willies. Ted felt trapped by her stares, as if the Hanson girl was there to bear mute witness for all the dead people. All the dead women. He also wondered what effect she was having on the man in the black robes. Stu Hanson was hardly aware that his daughter was in the courtroom. His first concern that morning was to elicit for the record Ted's confirmation that he had waived a jury trial of his own free will. Should he find the defendant guilty, Hanson was not about to have the verdict overturned on a plea that Ted had not understood what he was doing. And then, dialogue from the trial, I guess. Hanson. Mr. Bundy, was that decision made on your part freely and voluntarily? Bundy. Yes, sir. Hanson. With full understanding of the fact that you have a right to trial by jury in this matter? Bundy. I understand, Your Honor, my right to a trial by jury, and it is my decision, the best decision I could come to, after speaking with my attorneys, that I would waive the jury in this case. Hanson gave an inward sigh. With no jury to play to, David Yoakum's opening statement was measured and businesslike. The prosecutor confined himself to a retelling of Carol Duranche's kidnap and Ted's later arrest, that curious bag of equipment in his car. The state, Yoakum concluded, will request this court in its powers as both judge and jury to find this defendant guilty as charged of aggravated kidnap. O'Connell followed with a good deal more force to his remarks. He told his friend the judge that the trial was going to be anticlimactic. Quote, like a Who's It's comedy. There's an awful lot of excitement, but when it comes down to it, there's not much there. An awful lot of smoke, but not much fire, end quote. He began his assault on Carol Duranche's credibility as a witness, contending that it would, quote, become apparent that this is a rather immature young lady, end quote. O'Connell went on to charge that here was, quote, the most obvious forced identification of anything I have ever seen in my legal career, end quote. He characterized Ted as the real victim in the case and finished with a flourish about the damn tragedy of his client to be charged with such a crime. Round 1 to O'Connell. Yoakum lost no time in getting to the core of his case. He called Carol Durant to the stand. "Take your time, Carol," he told her. "Let's go through it slowly, okay?" Hansen busied himself with note-taking as he listened to Durant's story. In a soft voice, she related how on November 8, 1974, she left her job at Mountain Bell at 6 p.m., drove home in her maroon Camaro, then went to the Fashion Place Mall in search of a birthday present. She arrived there at about 7 p.m. and remembered meeting her cousin Joanne, as well as the friend Jolyn Turner. Then, she testified as she stood in front of the Walden bookstore, a man approached her. And then back to the court dialogue. Yoakum. "Okay, as best you recall, Carol, what were the first words spoken to you by this man?" Durant. "He asked me if I had a car parked in the Sears parking lot." Yoakum. "Parking lot?" Durant. "Yes." Yoakum. "Is that man present in court today, Carol?" Durant. "Yes." Yoakum. "Where is he seated?" Durant. "Right there." Yoakum. "Will you tell me what he is wearing?" Durant. "A blue-gray suit." Yoakum. "You are referring to the counsel table?" Durant. "Yes." Yoakum. "May the record show the identification of Mr. Bundy?" O'Connell. "It may." Hansen. "It will." The judge kept scribbling away at his trial notes as Yoakum led his witness through the remainder of her story. She testified that she was duped into returning to her car with Ted on the pretext that he was a police officer, and there was a report that someone had attempted to break into her Chevrolet. Upon finding the car locked and undisturbed, Officer Roseland, in quotes, led Carol back through the mall to the back of a laundromat, which she said was a police substation. Leery, but still persuaded that he was indeed a policeman, the girl then agreed to drive with him to the Murray Police Department. His vehicle, she noted, hardly looked like a police car, a dented, rusty Volkswagen Bug with a tear along the top of the rear seat. She remembered that it was a light color, white or tan, although on the night of the incident she had told police that the car appeared to be light blue. O'Connell would later bore in on this inconsistency in her testimony, calling it an example of her extreme unreliability as a witness. But Judge Hansen, who owned a tan sedan, took private note of the fact that he himself had been to the Fashion Place Mall after dark, and that under the parking lot lights his car looked bluish too. Durant continued her testimony with the description of the attack and her miraculous escape. Then Yoakum asked her to recall the lineup. Court dialogue. Yoakum, were you able to identify him from your recollection of him on November 8th, Carol? Durant. Yes. Yoakum, did you have any trouble? Durant. No. Yoakum, did he appear any different than he did on November 8th? Durant. Yes. Yoakum, in what way? Durant. He looked more clean-cut. His hair was shorter. He didn't have a mustache. Yoakum, did you notice anything about his appearance that was identical to the way you observed him on November 8th? Durant, the way he walked. Yoakum, anything else? Durant, his face. Yoakum, any particular part of his face? Durant, no. Yoakum, do you remember any distinctive features, anything about his voice? Durant, he was polite, sounded like he was well educated by the way he talked. In all, Carol Durant had acquitted herself well on the stand, but the real test would be how she stood up to O'Connell's cross-examination. The advocate began by highlighting several of the inconsistencies in her various reconstructions of the incident. Back to the court testimony. O'Connell, is your testimony now that you did scratch this man, right? It is your testimony now that you did scratch this man, right? Is that right? Durant, because all my fingernails were broken. O'Connell, going to page 38 of the preliminary hearing, do you recall Mr. Yoakum asking this question of you? Do you recall ever scratching him with those fingernails? And your answer, no. Do you have an explanation for that? Durant, no. O'Connell, in fact, the officers on November 8th asked you if you remembered if you hurt the man in any way, and you told them no, too, didn't you? Durant, I don't remember. Ted's lawyer tried to cast doubt on her identification of Bundy. O'Connell, and you say he was wearing a mustache? Duranch, yes. O'Connell, shortly after the incident, you said that you thought it over and decided the man didn't have a mustache, didn't you? Duranch, yes. O'Connell, and sometime later you decided he did, right? Duranch, yes. O'Connell, when did you make that decision? Duranch, right after I decided that he didn't have one. O'Connell's strategy was to impeach Duranch's testimony, at the same time demonstrating his contention that the police had forced her into picking out Ted. You pretty well identify what you think the law enforcement officers want you to identify, don't you? O'Connell snarled. On redirect examination, Yoakum shored up his witness. Yoakum, did you, when you went to the lineup, know that the man who assaulted you, kidnapped you on November 8th, was going to be there? Duranch, no. Yoakum, did anyone tell you he was going to be there? Duranch, no. Yoakum, did you know his name? Duranch, no. Yoakum, did you know anything about Theodore Bundy on October 2nd at the lineup? Duranch, I don't think so. Then he led her back through the lineup itself. Yoakum, seeing Mr. Bundy at the lineup when he first walked into the lineup room, what did you associate that with, Carol? Duranch, when he first walked in was the way he walked on that night. Yoakum, what night? Duranch, November 8th. Yoakum, did you know immediately? Duranch, yes. Yoakum, and you are positive today? Duranch, yes. Going into the trial, Yoakum had considered the prosecution somewhat vulnerable on two accounts. One, the nearly 11 months between the time of Carol Duranch's abduction and her first tentative identification of Bundy. That was, he told Hugh, a prosecution minus and a defense plus. His other concern had been Carol Duranch herself. Carol was very timid, he explained. She looked down at the floor a lot. She wouldn't talk directly to you. Her inability to express how she felt was her difficulty. She'd get a question that she knew darn well the answer, but if she couldn't come up with it really quickly, she'd say, I don't know, or I don't remember. That's horrible for an eyewitness ID, especially in cross-examination. I talked to her about it, but it didn't help much because she continued to do it. Her 2.5 hours on the stand came to a close at 5 p.m. when Hansen adjourned the court for the day. Through her occasional sobs and confusion and fear had emerged a kind of gritty defiance to O'Connell's questioning. There had been no hesitation at all when she identified Ted as her assailant, yet she had been vague on key points, and her retelling of the incidents on the night of November 8th suggested an astonishing naivety and blind submissiveness to authority figures. Certainly it was plausible, many court observers felt, that John O'Connell was right. But the only view that counted was Judge Hansen's, and behind his mien of juridical propriety, the judge had formed some opinions of her testimony. Quote, in spite of what everyone seems to believe, I thought Carol Duranch was a very good witness, he told us. My feeling was very clear that she was a strong, positive witness, very thin, frail girl, and she was up against someone who is considered one of the finest criminal lawyers in the state. Yet she was really unshakable, very firm and positive. Day 2 of the trial brought Marlon Vortman to court. Each day, the trusted friend and informal legal advisor took notes on the testimony. Each night, he and Ted would review the day's developments, agreeing generally that the case was going well. John O'Connell successfully argued to keep one ancillary bit of evidence out of the case. Judge Hansen would not take into his deliberations the fact that Ted Bundy has type O blood, and that type O blood was found on Carol Duranch's coat collar the Monday following her abduction. But Yoakum pressed ahead Tuesday morning with his police witnesses, who reconstructed the odd circumstances of Ted's August 16 arrest. He was allowed to introduce Officer Ondrak's discovery of the handcuffs in Ted's Volkswagen trunk. Bitterly contested by the defense as immaterial and illegally obtained, the testimony provided invaluable collateral evidence. It was consistent with guilt. After the Tuesday afternoon session began, court reporter Ruth Price walked into Hansen's office during a recess. "Did you notice that?" she asked. "What are you talking about?" Hansen replied. "Well, he's changed his clothes from what he had on this morning, and he's parted his hair on the other side." Hansen hadn't noticed, and he wasn't really surprised. After all, this was an eyewitness identification case. But he recalls, as we went through the trial, I did notice some very conscious efforts on his part to change his appearance. His expression would so change his whole appearance that there were some moments that you weren't even sure that you were looking at the same person as you had been half an hour before, or the day before, or the morning before. Some weeks after the trial, Hansen read Vincent Bugliosi's retelling of the Manson case, Helter Skelter. In it, the former prosecutor tells of how Charles Manson's appearance could change dramatically with his mood. "That was exactly the impression I had of Bundy," said Hansen. "He is really a changeling." Yoakum next called Jerry Thompson and began with the detective's search of Ted's apartment. Yoakum: "Now, specifically with regard to the examination of the closet area of his apartment, did you notice any particular shoes located in that area?" Thompson: "I noticed shoes which resembled the type that I am wearing now, a loafer type, that I assumed a shiny patent leather type, 2 or 3 pairs." Here is another vital link for the prosecution. O'Connell would put on witnesses to testify that the Ted Bundy they knew wouldn't be caught dead in something as tacky as patent leather shoes. The suggestion that he might own several pairs was ridiculous and an affront to the defendant's dignity. Even Liz Kendall, who could wonder if Ted was a killer, couldn't believe him capable of wearing patent leather shoes. Thompson went on to describe the photo spread he had shown Carol Duranch on the 1st of September 1975. Yoakum: "After she looked at the photographs, what did she do with them?" Thompson: "She took a picture out of the stack and held it in her hand. She went through the rest of the pictures, handing me back the stack. She stated, 'I don't see anyone in there.' I then asked her how about the photograph that was in her hand. She stated something to the effect, 'Oh, this one, I don't know. Here,' and handed it back to me. I then asked her why she pulled that photograph out, if there was something significant about it. She stated, 'Yes, I believe it looks a lot like the individual, but I'm not sure.'" Yoakum: "Whose photograph was that?" Thompson: "That was Mr. Bundy's." On cross-examination, O'Connell hoped to demonstrate the quote-unquote forced nature of Duranch's identification. He asked Thompson about the Polaroid snapshots of Ted's car he had taken with Ted's permission on August 21. O'Connell: "Now, on September 1, when you went up to talk to Carol Duranch, you showed her the small photos of the automobile?" Thompson: "Yes, sir." O'Connell: "And she told you that she definitely remembered the tear in the back seat?" Thompson: "That resembled the tear, yes, sir." O'Connell: "Then you told her that although she had seen a lot of photos, you gave her this packet of photos?" Thompson: "Yes, sir." O'Connell: "And you just said that she went through the process, took Mr. Bundy's photo out, and gave you the pack back and said that the man isn't in there, right?" Thompson: "Correct." O'Connell: "Then you said, 'What about this one?' indicating the one she had in her hand?" Thompson: "Yes." O'Connell: "And she said, 'I don't know,' right?" Thompson: "Similar to that. I don't know, it resembles the individual, or..." O'Connell: "You just testified that she said, 'I don't know,' and then you asked her again, and at that point she said, 'It looks like him.'" Thompson: "Yes." O'Connell: "Is that the way it happened?" Thompson: "It's possible. I don't recall the exact wording with her at that time." O'Connell: "All right. Then you testified here just a minute ago that after being asked twice about that photo that was in her hand, she said, 'It looks a lot like him.'" Thompson: "Yes." O'Connell: "Didn't you say after your second questioning about Mr. Bundy's photo, after saying, 'I don't know,' the first time, the second time she didn't really say it looks something like him?" Thompson: "Similar conversation. I don't recall her exact words." O'Connell: "Then she said, after she said it looks something like him, she says, 'I really don't know,' again, right?" Thompson: "Something like that." O'Connell, well, don't you think there's a difference between a witness saying that looks something like him and that looks a lot like him? Thompson, yes, I think there's a difference. O'Connell, all right. Well, what you said in your report is she said it looks something like him. You really don't know? Thompson, yes, sir. O'Connell, and that report was dictated about the time, right? Thompson, it would have been dictated that day or probably the next day by me. Then O'Connell turned to the second photo lineup, the one where Detective Beale from Bountiful showed DeRanche Ted's driver's license picture taken in December of 1974. O'Connell, you knew it was improper, didn't you, to show a witness two different pictures of the same individual? To show a witness another picture of an individual after she had made somewhat of an identification. This looks like him. Thompson, I figured it was improper to show the same photo, but an entirely different one that looked so much different. I didn't feel there was anything wrong with it. Hansen had been impressed with O'Connell's spirited questioning. He was not persuaded, however, of the defense's primary contention. By now he was familiar with the uncanny changes in appearance that would come over Ted in the courtroom, and he noted how different Ted looked in his August mugshot and the driver's license photo taken the December before. Unless you know who you are looking for, thought Hansen, quote, it would be very hard to identify him from any of those pictures. She had to have a pretty good image to begin with, end quote. That image was O'Connell's first point of attack after the prosecution rested Wednesday morning. The defense's initial witness was Dr. Elizabeth Loftus, a psychology professor from the University of Washington and an expert on memory. Before she could begin, however, Hansen had to rule on a prosecution objection to the use of an expert. Hansen, the state argued, didn't need any help in evaluating Carol DeRanche's reliability. The judge did not buy their argument. The Utah Supreme Court and the United States Supreme Court, he noted, have recognized that eyewitness identification is the most problematical type of testimony that can be offered. Objection overruled. Loftus testified that the term unconscious transference refers, quote, to the mistaken recollection or the confusion of a person seen in one situation as a person who has been seen in a different situation, end quote. She illustrated the phenomenon with the story of a railway clerk who identified a sailor as the man who had robbed him, when in fact the sailor had previously purchased tickets from the clerk. At a lineup, the sailor's face looked familiar, and the clerk identified him incorrectly as the thief. Loftus went on about concepts such as the retentional interval in memory, the forgetting curve, and cueing. In the latter, she told the court, quote, the experimenter who has a hypothesis can make his experiment come out to conform to his hypothesis unintentionally, unquote, unquote. She also reported that experiments have shown that viewing hundreds or thousands of photos, as Carol DeRanche did, can affect memory, and there seems to be no relationship between the confidence of eyewitnesses and the reliability of their identification. The part of her testimony that most intrigued Hansen had to do with stress. In a move he would not have made had there been a jury, he asked a few questions of his own. First, he wanted to know if being a victim of a crime could affect memory. Memory performance is going to be lessened, she answered. The judge pressed her further. And back to the court dialogue. Hansen, let's assume you have a time continuum as represented by a straight line. At one point in time, there is no stress whatsoever. As that continuum line proceeds, the stress begins to build. The victim begins to suspect that she might be a victim. At a point further down the line, the victim becomes assured of the fact that there is a real problem. How would stress in your judgment affect eyewitness identification under those circumstances? That is, would the victim be more likely to be able to identify the perpetrator under those circumstances than in a situation where there was a sudden violent event like a breaking in through a door or window? Loftus, my guess is that the sudden event would produce a less accurate identification because the whole experience would be while the victim was in an extreme state of stress. Hansen was intensely interested in the doctor's reply. Her answers were very revealing, he said. What she was saying was that eyewitness testimony is inherently frail. So I asked her a hypothetical question about a hypothetical situation which happened to fit the evidence in the case. I remember she said that it would be a valid circumstance for a good eyewitness identification. O'Connell's next witness was Edward M. Barton, the former chief criminal investigator for the Salt Lake County Attorney's Office. Barton testified as to the quality of evidence that usually was required before he could go to the county attorney to ask that a subject be charged. Back to the court conversation. O'Connell, you wouldn't rely solely on eyewitness identification? Barton, oh no, sir. Once again, Hansen took it upon himself to question a witness. Hansen, would you say that the lineup identifications procedure is or is not a reliable means of identifying a suspect? Barton, my personal experience was that it was not the best form of evidence. It was an investigative aid, but it was not the best form. On Thursday morning, February 26, O'Connell called Ted to the stand. Stu Hansen still didn't know if he believed Carol Duranche's testimony or not, and a credible performance by the defendant would mean a verdict of innocence. All Ted had to do was come up with a believable story as to just where he was on the night of November 8, 1974. Later, the consensus was that Ted was a disaster on the witness stand. O'Connell agreed that Ted damaged his own case. Quote, he just didn't seem right, but I could never figure out how he was supposed to act, and neither could Ted. If you were hated by 9 million people, how would you act? No matter what the guy did, it didn't seem right, end quote. Ted's story was that his car broke down the afternoon of November 8, 1974, and that he pushed it into a gas station where a mechanic helped him to start it. He drove home to his apartment around 5 p.m. Quote, obviously I can't recall too much past that point, he testified, except I'm sure I went to my house, and I guess I'd have to say I suppose I had dinner. Later on, Ted remembered he went out to try to start the car but couldn't. He was trying to appear innocent, adding, I'm not going to fool anybody. It's hard to think back 10 months, 12 months, 16 months now. But the apparent candor seemed affected. The rest of that evening, according to Ted, he probably walked down to Salt Lake's Trolley Square to see a movie. Then perhaps he had a beer at the pub. He knew he was home by 11:50 that night because his telephone records show he called his girlfriend in Seattle at that hour. Specifically, he denied having been at the Fashion Place Mall or having had any contact with Carol Duranche. He repeated his silly explanation of the handcuffs. Quote, in the early part of 1975, in the course of doing work for my landlord, I took things to the Salt Lake City dump and I found them in a box of odds and ends there. Then back to the court document. O'Connell, why did you take the handcuffs? Bundy, I don't know. Why not? They just seem to be something. On cross-examination, Yoakum reminded Ted that he had told Detective Forbes that in Seattle he had once apprehended a thief and had had to restrain the suspect until the police arrived. Having handcuffs he felt might be useful if such a circumstance should ever arise again. In addition to pointing out the discrepancy in Ted's explanations, Yoakum wanted to demonstrate the weakness of Ted's initial claim. And back to the court documents. Yoakum, did you ever have a key to those handcuffs? Bundy, I don't believe so. Yoakum, wouldn't be much value to you in apprehending people without a key, would they? Bundy, well, again, if that was my purpose, as I say, the absence of a key was one of the primary factors in saying they were more of a curiosity than saying something one could use that would have any utility. Yoakum, but you told Forbes you were going to use them to restrain people, is that right? Bundy, Detective Forbes had informed me that his game was homicide. I must tell you that he wanted... Yoakum, answer my question rather than editorializing. Bundy, sure. Would you re-ask the question? Yoakum, you don't remember it? Bundy, no, I don't. Yoakum, you just want to answer the way you want to answer, right? Bundy, that's right. Ted had cobbled up another story to explain why he hadn't admitted to even John O'Connell that he'd been smoking marijuana the night of his arrest. I didn't see any purpose in telling you. He testified. I was quite embarrassed by it. It's not something you care to admit. Yoakum pounced on that story, pointing out to Ted that as a law student, he would know that an admission of having smoked a joint could not be used as evidence against him. Furthermore, possession of marijuana is a simple misdemeanor in Utah, while possession of burglary tools and attempting to elude arrest carry a higher potential penalty. Yoakum asked if the arresting officers had questioned Ted. Back to the court document. Bundy, I was questioned, yes. Yoakum, and the thrust of their questioning did not go to the question of marijuana use, did it? Bundy, it did not, thank goodness. Yoakum, do you remember what you told the officers about the crowbar in the automobile? Bundy, I can't remember specifically. I think I may have told them that I had been using it that day, shortly before that day. I can't tell you exactly what I said that evening. Yoakum, a crowbar of this nature is not exactly a tool that you would use with regard to repairing your automobile, would it? Bundy, well, it's a useful tool. What can I say, Dave? Yoakum welcomed Ted's mocking civility, which, like Ted's manner with the police, was backfiring badly. The prosecutor grew more insistent. He questioned Ted about the nature of his troubles on November 8th. Ted explained the trouble was the result of neglect, not the sort of difficulty that crops up suddenly. Back to the court document. Yoakum, how was your car running, say, the 2 weeks prior to November 8th? Bundy, I suppose it was running. A Volkswagen will run. Yoakum, in fact, you were running the wheels off it, weren't you? Bundy, I can't recall. Yoakum, didn't you purchase gas on the 25th, 26th, and 28th days? O'Connell, Your Honor, he's going into collateral matters. It's outside the scope. Yoakum, it's not, Your Honor. He talked about his car not running well. It goes directly to that point. Hansen, the objection is overruled. Yoakum then asked Ted if he had purchased a total of 22.7 gallons of gas in a 4-day period in late October, all within the Bountiful Murray, Utah area. Bundy, I guess if you added it together properly, that's what it is. Yoakum, how many miles to the gallon do you get on that car? Bundy, well, when it's not running efficiently, it drops quite low. I can't say during that period. When it's running at peak efficiency, it will run at 28. When it's not running well, it will run down 22, 23, maybe as low as 20 miles per gallon. Yoakum, so you can tell me generally in your head how many miles you traveled on 23 gallons of gas? Bundy, well, no. O'Connell, I object. This is a math test. Hansen, the objection is overruled. Yoakum, have you computed that yet? Bundy, oh, I'm not really thinking about it, Dave. I thought you made your own conclusion. I'm not here to do mathematical problems. O'Connell sensed that his client was alienating the court with his sass. He jumped up to shut off Yoakum's line of questioning. O'Connell, may the court take judicial notice of the fact that 20 times 23 is 460. Yoakum agreed to the stipulation. The highest opinion of Ted's testimony was his own. He gave himself a C+, he told me. Says Hansen, I was really very absorbed by what he was saying. I had no strong feelings about him one way or the other. He was a typical witness who was getting on the stand to give an explanation or an alibi. He was obviously very articulate, and he obviously knew exactly what he was saying. I ended up by not believing him. Closing arguments were completed at 1:44 p.m. on Friday, and Hansen adjourned the trial to consider his verdict. For the judge, it would be a long weekend at home in his study, sifting through every piece of evidence, reviewing his extensive trial notes, and cataloging his recollections of the trial. Friday night, he took his wife out to dinner. By Saturday morning, I'd worked myself into such a state that I was really wrought up about it. I didn't leave the house again until Monday morning. Ted spent the weekend with Liz Kendall, who flew down from Seattle on Thursday night. He had lured the confused woman back into his orbit. Though Liz would eventually break from him to be supplanted instantly by Carol Boone, She was, at the time of the trial, ready to believe again that her boyfriend was innocent. They made love for the last time on Sunday afternoon. Hanson's decision did not come to him in an instant. Quote, I think I delayed making up my mind for as long as I could, he told us. It is one thing to have doubts. No one knows anything for certain. But reasonable doubts are another thing. I would say that fairly early on in the weekend, reasonable doubts disappeared. Then it was a question of going over and over the material to be sure, end quote. Hanson called everyone back to court at 1:30 p.m. on Monday, March 1st. The judge looked like death warmed over when he came in, remembered O'Connell. With Ted standing before him, Hanson intoned, I find the defendant, Theodore Robert Bundy, guilty of aggravated kidnapping, a first-degree felony, as charged.